Fiore.
Good morning. I guess I'd like to save about 5 minutes for rebuttal.
That's fine.
Okay. Dorothy D. Fiore, I represent the Mr. Shaver. We're the appellants. This is an appeal from a final jury trial in which the jury assigned several sets of damages against Mr. Carpenter and his wife, or against Mr. Shaver in favor of Mr. Carpenter and Mrs. Carpenter. We've raised a couple of issues, two of which we feel justify an entirely new trial, two of which relate to damages.
One request and then one question. Can you move the mic a little closer to your face? We're not picking up microphone on.
Is that better?
Yeah.
Okay.
And just to confirm, Geico is actually an appellee in this thing, but the judgment against them is only like a cost judgment. So that's not an issue on appeal. Is that right?
No. More accurately, Geico insured Mr. Shaver with the policy limits, and Mr. Brennan's method of dealing with that is to get a joint and several final judgment against Geico for the policy limits that unquestionably are owed if the judgment sticks, and then the excess verdict that would be something that would be subject to Geico's bad faith would be recovered later. So that's how he does that. He gets a final
judgment. The judgment we
judgment.
have here on appeal shows money assessed against Geico, and Geico has separate counsel and has not appeared, so they're an appellee. Is that right?
Well, I don't think we named them as an appellee. I didn't really think about
rules
make them one?
them one.
Okay.
Yeah.
Yeah, I don't think that Geico has come in terms of objecting to the joint and several judgment against them. However, the judgment against Mr. Shaver is reversed.
Okay.
And obviously, the judgment against Geico is reversed. Again, we've raised a couple issues, two of which we think warrant a new trial altogether. The first issue is related to Trooper Mosesman's testimony. Trooper Mosesman was directly asked over objection, and several objections actually, whether or not he believed that Mr. Shaver violated the right-of-way and whether Mr. Carpenter did not. And Trooper Mosesman specifically said, yes, that's what I think. I think that they violated the right-of-way. Thereafter, in closing argument, counsel, having had the jury instructions read to the jury, this is a statute that says you might be in violation of the statute, it's evidence of negligence, and the counsel stood up and said, so there you've heard this is a violation of the right-of-way, and you heard Trooper Mosesman say this was a violation of the right-of-way.
Well,
so,
as a practical matter, if I've got this laid out in my head right, we've got the defendant's car going one direction on a lane in a turn lane, but not with no special light.
yes.
And we've got a motorcycle coming the other direction on the same road.
Right.
So both of them ought to have the same color light, whatever color it is at the moment. And your client waits for some vehicles and then turns in front of the motorcycle.
Well, but
Isn't that violating the right-of-way no matter how you look at it?
not if the light was red. If the light was red, then he was turning in order to...
If your client turns on a red light and turns in front of another person with a red light, he's not violating anyone's right-of-way.
He may be running a red light, but he's not violating the right-of-way because they should have stopped. And in fact, I believe the evidence of what color the light was a little equivocal because not anybody was looking right at the light at the time that they were pulling out. It had been green, no question about that. A witness had been coming behind or on the same path, said, you know, I don't know whether it was green or red because I'd stopped and I was waiting, so I'm thinking it's red, but now later on I'm looking back and maybe it wasn't. The other guy that was in the perpendicular, he says that it was red for him, but the experts testified that there was a delay, so that once the red light for Mr. Shaver and Mr. Carpenter turned red, once the light turned red for them, it could also have been red the other way. So the fact that they were both red at the same time was not, you know, in other words, the other guy. So, I mean, Mr. Shaver said basically he was trying to make the left turn. And I think we've all done it where we said, okay, now the light's turning red, so now I can turn, expecting that oncoming traffic also getting a red light would stop. And what the trooper didn't have was all of the statements. He didn't have the full investigation. But instead, he was still allowed to elicit his opinion that Mr. Shaver had violated the right-of-way, which was essentially telling the jury, I gave them a ticket and I find them negligent. Because when you're looking at whether or not the accident was caused by the negligence of someone, and it's a question of did they turn in front of them, the only way they're going to be negligent is to violate the right-of-way.
Was that opinion tested on cross-examination?
Excuse me?
Was that opinion tested on cross-examination?
Yes, it was. Mr. Haas.
What you're telling us today about what could have been and what might have been, the jury heard those those theories?
Well, the jury heard a lot of the reasons why Trooper Mosesman's opinions should not have been given a lot of weight, but at the end of the day, they still heard the investigating officer reach the conclusion that they violated the right of way, and it was directly tied in closing argument to say this is why Mr. Shaver's negligent, because Trooper Mosesman told you that he violated the statute.
And this is one of the few intersections that didn't have a red light camera.
Apparently. So we question the debate about whether those red light cameras are worth it. We feel that the evidence in this regard is very prejudicial. We think the case law clearly shows that this is a type of prejudice that justifies reversing the child. I think the most directly on-point case is the Hernandez versus State Farm case, which is 700 Southern 2nd, 451 out of the 4th BCA, came from 1997. And there, the officer concluded that the plaintiff had failed to use the right of way. And that was essentially what the officer said. Sounds a lot like what Trooper Mosesman said. And the 4th District concluded that that was reversible error because the suggesting that a driver has been charged or suggesting that they are the fault in the accident is reversible error. There's, of course, a legion of cases that address that you can't elicit the citation and who got it and who didn't. And I think this was nothing more than a mere subterfuge to put that exact evidence in front of the jury, was that, in fact, they had been charged. And he did it in a little bit, he didn't actually come out and ask the question, but he used the term violation of right of way, he had the statute read, and then in the closing argument he directly connected the dots and essentially told them exactly the same thing. So whether it's violation of the statute or the citation, who got the citation, or it's who was at fault for this accident, at the end of the day the trooper gave an opinion on two things that he should not have given an opinion on. And the Albertsons case makes it clear why that kind of evidence and that kind of testimony is particularly damaging with lay members of the jury. In this case, the liability for the accident was a very significant issue because, again, if you're just turning on a red light and somebody should have stopped, then you should not be responsible for 100% of the damages there. I contend you might not be responsible for any of them because if in fact you should have stopped, then you're responsible for your own damages. And we had to present substantial expert testimony indicating that Mr. Carpenter should have been able to stop. And of course, if the light was red for him, he should have been stopping in the first place. So had he been able to stop, he would have been safe and he would have had no injuries at all. So the issue of negligence and comparative negligence in an intersectional kind of collision is a very key issue. And Trooper Mosesman's testimony particularly damaging. The next thing we think was highly prejudicial to the defendant, and if you want to look at it singly by itself, that's fine, but let's add that on top of the prejudice we just had from Trooper Mosesman, was the use of the surveillance interrogatories. Now, Mr. Carpenter had had some fairly significant head injuries, and he had not been wearing a helmet. And in the beginning of the case, the head injuries were an issue, but they were later withdrawn because of the helmet. So some of the surveillance was going to the extent of those kind of injuries. But of course, you're entitled to surveil somebody. It's an expected part of the discovery in a case. Mr. Carpenter also had worked in a very heavy labor industry. He is a construction man, and he worked really hard, and he had not been kept out of work, and he had injuries from before the accident that were a little bit consistent with some of the injuries had in this accident, and he had treatment for those injuries. So the fact that the defendant wanted to find out if there was evidence that was completely inconsistent with what he was testifying to is a legitimate concern. At the end of the day, the defendant decided not to use the surveillance tapes. Now, it's been suggested by the appellee that that's because it, in fact, corroborated the plaintiff's position, but that's not true, and there's no evidence to support that in the record.
In the record, there's no information about what would be in those tapes.
Exactly. At the end of the day, you might decide.
Was there any cross-examination? Was there anything done that was based on this investigation during the trial by the defense?
Not that the records reflects, and I wasn't the trial attorney, but to my knowledge, no. In other words, the surveillance just didn't produce anything that the defense felt was going to be productive at the trial. So I'll agree there may not have been anything directly impeaching him, showing him doing cartwheels going down the driveway type of thing. Nobody's moving a refrigerator, but at the end of the day, that doesn't mean it corroborated the plaintiff's position either.
Is there any case law directly on point as to the introduction of such interrogatory answers for these purposes?
That's the interesting thing is there's not. Dodson versus Purcell says you can find out about it, and if you're going to use it, you definitely need to have your prejudice from not knowing what they're given to you so you can look at it. But absolutely nothing says whether or not the fact that there was surveillance and whether it occurred, that type of thing. There's no cases that even talk about it. And here,
It just comes down to just a question of relevance.
relevance. And how did the defendants use this, or how did the plaintiffs use this? They used this to malign the fact that the defendant was defending the case. We're not worthy. They said we aren't worthy of their money, and all they want to do is malign us and embarrass us and humiliate us. Look at this, they surveilled us. And that was the theme throughout the closing argument, was that the defendant didn't have a right to defend the case and didn't have a right to make them prove their damages, and look at all the bad things they did to you. You know, things like asking you questions about your injuries, about having you examined by an independent doctor, all the things that in fact a defendant would be remiss in defending a case if they didn't do those things. And then they added to that, oh, and then you spied on us. They didn't just use surveillance. No, they used spy. You spied on us. And of course, when did this happen? This happened during the time that the whole National Security Administration's big surveillance things comes out. So you combine the word spying on the plaintiff as the implication that they're not allowed to be defending this, that somehow they're treating the plaintiffs as like dirt and they're maligning them. And the whole specter that was created was that these defendants were overbearing, overreaching, and just being horrible to these plaintiffs.
Was any kind of a cautionary instruction asked for before the jury heard that evidence?
I believe there had been addressed so much extensively, both before the trial, during the trial, that at the point in time where it came up during the closing argument, Mr. Haas objected and came up to the judge and said, see, this is exactly what we said he was going to do with this, and that was about the end of it.
So a cautionary instruction was not...
I don't remember seeing one. I doubt if so one was. So, and we believe again that adding that type of prejudicial behavior toward the defendant when there's a close question of comparative negligence, that the two combined together results in a need for a completely new trial. We've got an antipathy that's been created toward the defendant on a question that's fairly close in terms of who was really at fault, and now they've made them look like very evil, mean-spirited, spying people. And those two situations, we believe, create a situation where an entirely new trial is warranted. When we look at the future damages and the past medical damages, we think there's also some issues, and whether it's a new trial on damages or remittitur, that's always one of those tough calls to make.
And I was going to ask you about that, but in reading through this, there was a motion. It appears to me that you're arguing that the motion for remittitur should have been granted, not a motion for a new trial, or both.
From my perspective, and I think that the evidence was...
Were there both motions or just a motion for remittitur?
There was both.
Oh.
Yeah, Mr. Haas is very careful about those things. And so that if in fact you don't think it was that bad...
Or excessive damages?
I think in regard to Mrs. Carpenter that there is excessive damages, and in regard to Mr. Carpenter, there is the basis for any future medical is just so weak that it just couldn't have even gone to the jury. Dr. David said the best he could come up with is the canned answer is, and then he rattles off $1,500 to $2,000 a year.
Especially on the wife, from a remittitur standpoint, what would be the amount of the remittitur?
Well, and I went back to look at that, and the jury verdict is not supported by the testimony and the evidence that was in there. So on closing argument, Mr. Brennan suggested that there were 2 knee surgeries that were needed at $68,000, and that's $136,000. And Dr. Davidson testified from our perspective, a very random, speculative, some people require this kind of approach, that there would be some injections and other kinds of therapy, and he estimated that at $3,000 a year until they get the knee replacement. So if you had the $3,000 a year for the 10 years, the knee surgery in 10 years, the knee replacement in 10 years, the second knee replacement, you're only up to $166,000, but the jury awarded $240,000. So we don't know where the other $34,000 even came from.
And I have it in my mind that someone was suggesting that the future knee surgery was like $500,000 or something.
I don't remember seeing that anywhere in the record. So, and again, I wasn't at the trial. So, but in terms of reduction, we think the second knee surgery, when the lady's 80 years old, if it was all based on if this, if, and this is what happens to these people, the standard language.
The question was asked, is this all based on reasonable medical certainty? And
Yes, it was.
says yes.
Yes.
And I think we all know that
Knees and hips wear out if you get the replacement too early in your life. I mean,
And that's pretty much what the doctor said, is knees and hips wear out. What he didn't say was Mrs. Carpenter's knee replacement's going to occur, and then by the time it gets to a certain age, it's going to wear out. I think what happens is there is a standard, just like Dr. Davidson honestly says, a canned answer about what happens in a standard situation. But that isn't a reasonable degree of medical certainty that Mrs. Carpenter, who has managed to go several years without needing the injections, without needing any kind of treatment, without needing the therapy. So she's a pretty good lady in terms of her recovery, in terms of her pain management. So she is not necessarily your typical patient. So to say that what happens to the generic universe of patients is going to happen with reasonable certainty with Mrs. Carpenter, that isn't in this record. But at the very least, we think Mrs. Carpenter's second surgery, and again, that $34,000 that I have no idea where it even came from. I went through Cottrell's testimony to try and figure it out, and I never could find an answer for that.
The interrogatory verdict doesn't break out one surgery versus another.
No, it does not.
How do we factor that in?
Again, as we put in our reply brief, there was only one issue, was the damages. The evidence was pretty specific when it came into test from Dr. Cottrell, and counsel put out some pretty specific numbers in closing argument. So I think if you could just take out the $68,000, that's fairly simple for the second surgery. And again, he testified about the $3,000 for the injections every year, kind of just rounded that one off.
Down
so,
to your 5.
Okay. I'll take it off my rebuttal, but one note on the back and the shoulder for Mr. Carpenter. Again, the back treatment in the future, it just so little was there. I mean, counsel in closing recognized there was very little there. The answer was very generic, but canned. And on the shoulder injury, Dr. Foley was the only person who saw both all of the before and all of the after records and said that the shoulder injury was not caused by the accident. Dr. Carlin very handily recognized that he had not seen anything and was relying on a history that was very clearly in the record inaccurate.
Thank you. Mr. Eaton?
Good morning. May it please the court, my name is Joel Eaton and I represent the plaintiffs, Mr. and Mrs. Carpenter. I have to warn you at the outset that I have reached mandatory retirement age. My hearing aids help me a little bit, but if you could speak a little louder, I would appreciate it. As to the principal issue on appeal, the evidence was absolutely undisputed that Mr. Shaver turned left in front of an oncoming motorcycle on a green light. He testified he had a green light. He told the trooper he had a green light. The Carpenters, both of them, said they had a green light. A bank president parked perpendicular to this intersection testified he had a red light and therefore the collision occurred on a green light. There was absolutely no evidence whatsoever from which Ms. DeFiore can tell this court that there was some dispute about whether this turn happened on a red light or not. Now, there was one witness who was deposed earlier in the case who gave some ambiguous and equivocal testimony, which the jury, had it heard it, might have decided that there was some question about the status of the light. The defense called that witness to the stand. He disavowed what he said. He said that the deposition transcript was a mistake, that he had only been stopped at the intersection for a few seconds, that he didn't see the accident, and he didn't know what color the light was. So it is absolutely undisputed that Mr. Shaver violated the Carpenter's right-of-way.
There's apparently some evidence that these lights were red both directions for a period of time. Does that factor into this at all?
No, Your Honor, both of the defense experts, neither one of them testified that Mr. Shaver did not violate the Carpenter's right-of-way. Their only opinions were that the Carpenters could have stopped in front of this car that turned in front of them. That was it. There was no dispute. So my bottom line argument is that any error which occurred when the investigating trooper stated his opinion is perfectly harmless. But my principal position is that this issue was not preserved for review. The only objection that related to this testimony on an ultimate issue thing from defense counsel was that he didn't want to hear questions about who do you believe was at fault in the accident because that will invade the province of the jury. And I assume we will steer clear of all of that with all the witnesses as well as Trooper Mosman. I just wanted to let you know that. Plaintiff's counsel said, I understand the difference between who's at fault and who breached a standard of care. And the standard of care in this case was set by the statute that requires you to yield the right-of-way to oncoming vehicles.
So when the trooper is actually on the stand and this question is asked him, is there an objection at that point in time?
This colloquy in which Mr. Haas said, I don't want to hear who's at fault, occurred before he was voir dired.
Right.
There was an objection at the time the opinion came out. It consisted of one word, objection.
Okay.
That's it. So this issue was not preserved. On the merits, however, it is permissible to ask an opinion from an expert on an ultimate issue of the case. Section 90.703 of the Evidence Code says you can do that. There is a wrinkle, however, in Town of Palm Beach versus Palm Beach County. The Supreme Court said, well, it may be a matter of semantics, but what you can't say is that my opinion is the defendant was negligent. You can ask if, in my opinion, the defendant breached a standard of care. Happens all the time. In this court, I cited an opinion from this court, quoted from it, which explains that the difference may be semantic, but it's an important one. The trooper was not asked for his opinion as to whether Mr. Shaver was negligent. He simply asked if he violated a standard of care, the right to yield the right-of-way. So I think this issue is much ado about nothing. One, because it wasn't preserved. Two, it's wrong on the merits. And three, it's clearly harmless from whatever vantage point the evidence can be viewed. The more interesting question to me in this case is whether the trial judge abused his discretion in overruling a relevancy objection to plaintiff's counsel reading answers to interrogatories which disclosed that the defendant hired a private investigator who photographed and videotaped the plaintiffs 8 times over a 1-month period. And that's all that the jury heard.
But it turned in through closing argument to sort of a cause of action for invasion of privacy or something, and that is troublesome.
Not exactly. Let me give you some context. The principal defense here was to attack the credibility of Mr. Carpenter, because the opinion on the prior shoulder surgery was bottomed on the history that he gave to the orthopedic surgeon. They brought in a forensic radiologist, more of whom I'll have to speak about in a minute, who testified that the comparison of the 2 MRIs, the one taken when he was being treated by a chiropractor and the one taken after the accident, were exactly the same, and he wasn't injured, and that in effect he was lying when he said that he was lying when he told the treating orthopod, didn't tell the treating orthopod, about the prior injury. The whole thing was an attack on Mr. Carpenter's credibility. They attacked his credibility on another issue as to whether he was terminated from his job because of the shoulder injury or because of the lack of business. There was a dispute about that. They could not possibly have had a defense on liability in this case, so they went after these plaintiffs on the issue of credibility.
Now, the issue of questions, probably this is more curiosity on my part. Why did they talk about the surveillance interrogatories and not show the video? Because really deep down the video was supposed to either show that they were perfectly fine or there was something wrong. And if they showed they were perfectly fine, then why wouldn't the plaintiff put that
to show 8 videos taken over a month period is going to take another 2 days worth of the trial.
Was the jury instructed the 8 videos showed nothing germane to this case?
No, Your Honor. Now, Ms. DeFoy has argued in her reply brief that it's pure speculation as to what these videos would have shown, and therefore the judge abused his discretion in allowing in the answers to interrogatories. But it is not speculation. There is a reasonable inference to be drawn from the fact that this gentleman wasn't believed by the defendant or its insurance company, such that they hired a private investigator and spent hundreds of, maybe thousands of dollars videotaping this guy over 8 separate occasions. And
if he's not believed about history and causation, if you will, these tapes are going to go to, maybe extent of permanency and the extent of injury. They don't really, at least directly, go to whether he's telling the truth about medical history and causation, do they?
No, but why do you videotape somebody if not to prove that the position that he's taken at the trial is a lie? We got films that show that he's doing the things he says he can't do. He's a liar.
So if you challenge the accuracy of the witness in any respect, then those tapes always come in, even though they were aimed at damages, really?
Why doesn't the defendant take that risk when he spends thousands of dollars trying to prove that the plaintiff is a liar? What's sauce for the goose has got to be sauce for the gander, and Dodson versus Purcell does not support the argument that they're making, that you can only do what the plaintiffs did in this case when the defendant chooses to utilize the surveillance materials at trial. That's not what Dodson says. It just doesn't say that. And normally I don't like to read from cases because it puts people to sleep. But
Dodson just doesn't reach this.
It doesn't reach the issue.
I mean, it says you're entitled to know about this before trial. So, because so many times before that these things popped up on rebuttal and there was surprise and all that. So nobody's surprised anymore. But it doesn't really reach this issue. And while I'm in the midst of that, I haven't read this part of the transcript at this point in time, but I've seen in the briefing that one of the jurors had a question about
what's the relevancy of it?
Did somebody answer that question at that point in time? Was the question to the judge? I'm not sure who this question was to. Yeah.
Well, it's been such a long time since I read this transcript that I can't give you an accurate answer to that. But Dodson doesn't deal with the specifics which are before the court in this case, but it does deal with the issue in a general way. And what it says is that you can get discovery of surveillance materials whether or not the defendant intends to use them at trial. So the fact that we got these answers to interrogatories was perfectly legitimate. Dodson goes on to say, we hold that upon request, a party must reveal the existence of any surveillance information he possesses, whether or not it is intended to be presented at trial. What we require is that a party must disclose the existence of material which is or may be relevant to the issues in the case, whether as substantive, corroborative, or impeachment evidence. Relevant evidence cannot be allowed to remain hidden in a party's or an attorney's files. So that's what Dodson says. So the question here is whether there was an abuse of discretion in overruling a relevancy objection to these answers to interrogatories. At least that's the way I see the question before the court. Now, when you stand up and argue to the jury that you cannot believe the orthopedic surgeon's reasonable medical probability causation testimony because it's bottomed solely on what Mr. Carpenter told the orthopedic surgeon, you're asking the jury to find that Mr. Carpenter is not telling the truth. Well, we set out to see if he was telling the truth 8 times. And there is a reasonable inference from the fact that they haven't brought any of those tapes to you, that there's nothing on those tapes that shows Mr. Carpenter is not telling you the truth.
Taking that position, factor in the assertion that those tapes were really, the surveillance was really done more directed to earlier claims that the plaintiff dropped.
You know where Mr. Forey came up with that information? A statement made by defense counsel in closing argument. There is absolutely no evidence that these, in the record.
Well, there's not going to be any relevance, evidence at trial, I don't think, if you drop the claim.
I don't think there was even an objection about we were looking for head injuries and not something.
That's relevance, you know, and the assertion here is that the only relevance would have been, if I assume, if that claim had continued, but the claim had been dropped.
The only basis for that argument is a statement made in closing argument by defense counsel, which is unsupported by any evidence in the record that the jury heard. The jury did not hear any of that. All it heard was the answers to the interrogatories. And because the principal defense in this case was don't believe these plaintiffs, we don't believe that the trial judge abused his discretion in allowing these answers to interrogatories into evidence. Dodson does not say it's okay to read answers to interrogatories, but it says once you discover it, and you can discover it whether it's going to be used at trial or not, you can use it if it's relevant to the issues in the case, whether it's substantive, corroborative, or impeachment evidence. At least reasonable people may disagree about that ruling in this case, but I don't see how it could possibly have affected the liability finding in this case.
Did the answers to interrogatories, by the way, distinguish between investigation as to Mr. Carpenter and as to Rebecca Carpenter?
I'm sorry, Your Honor. Louder, please.
I'm sorry.
I'm loud
enough in general, but I was curious as to whether the questions specified whether the investigation was of either Mr. Carpenter or Mrs. Carpenter. Do we know who they were watching from these answers to interrogatories?
My recollection is that the question was generally phrased in terms of, do you have any photo or video evidence of surveillance of either or both of the plaintiffs? Yes.
Okay. Okay.
Now, the three challenges that have been made to the sufficiency of the evidence to support the damage awards are mere jury arguments. All three expert witnesses who testified about the causal relationship or the necessity for future damages testified to a reasonable medical probability. Now, there was some cross-examination in which the trick question was asked, but you're really speculating. Well, speculation to a lay witness means something different than it does to a judge on a district court of appeal. Any opinion about what might happen in the future involves some speculation, but you can speculate about the future based on probabilities.
But if a doctor said, for instance, well, I don't know, I'm not sure as to the specific question, but the end of this, I'm not sure, but blah, 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 but at the end of the testimony, you know, the counsel says, now were all the opinions you've given here based on reasonable medical probability? He says, yes. Is that sufficient if he's already qualified his specific answer is basically a canned answer because I don't really know?
A plaintiff has a burden of presenting expert testimony on issues like this to a reasonable medical probability, and that's exactly what the testimony was. Then on cross-examination, that opinion may or may not have been undermined, but the cases are clear that a jury is entitled to believe one part of a witness's testimony and disbelieve another. What you can't do is direct a verdict or order a remittitur or order a new trial for insufficient competent evidence to support a finding of fact when in fact there is substantial competent evidence in the record supporting the award, and that's what we have here. This is not a place to remake the jury argument.
It's kind of the tail of the dog here, but the damages on the future medicals for Mr. Carpenter and that Dr. Davidson, I believe? Yes. Did Dr. Davidson, as compared to Cottrell, ever testify that this future treatment was going to be required by some degree of reasonable medical or the like?
He said that future treatments of this lower back injury were a certainty, but the difficulty he had was fixing an amount. So he came up with what he called a canned answer. Now, they can argue to the jury that you can disbelieve that canned answer because it's a canned answer, but the jury believed the testimony.
Was there any motion by the defense to strike the testimony as not based on reasonable medical support?
No, Your Honor. The argument is we got him to equivocate a little bit on cross-examination, and therefore you got to retry the case. But the jury heard reasonable medical probability supporting all three of these challenged awards. And in that circumstance, I don't believe this court can do anything but accept the jury's verdict. That's the jury's job, not your job, not my job. Thank you very much.
What is your response to the Remittitur issue on Mrs. Carpenter's?
Could you speak up a little bit? I'm sorry.
I'm sorry. What is your response to the Remittitur issue on Mrs. Carpenter's, on her numbers? You know, counsel has suggested that they just don't add up with the testimony.
I don't remember that specific challenge being made in the briefs, so I'm not sure I'm prepared to suggest it. You know, I won a case in the 4th District a long time ago called Lewis versus Barhouse, which applied the two-issue rule by analogy to a situation like we have here, where we have a lump sum award that's not differentiated, and the appellant is only challenging one portion of the award. Now, I haven't pushed that here at oral argument, and I didn't push it in the briefs, but I don't see how you can determine that some error was affected when you can't decide how much of that lump sum award belongs to a particular element of damages. I think they had an obligation to sort those things out with a special verdict form, and in the absence of that, you're kind of left hanging, seems to me.
Well, is there, you know, if they actually move for new trial as well as for Remittitur as to her future medicals, is there a distinction there? And the Remittitur to me seems difficult, but if it's excessive and you can't remit, is it abuse of discretion not to grant a new trial, at least as to this one element of damage in this case?
You know, remittitures are peculiar things. If you were to say to the trial judge, order a remittiture, you still give the option to both sides now.
Right.
To grant a new trial if the judge comes up with a number that neither party can agree with. But if the judge picks a number, whether it's supported or contradicted by the evidence, if both parties are agreeable to the reduction, then it goes away.
Okay.
Thank you.
Thank you. Ms. DeFiore.
I thought I'd address a couple of the court's questions. First of all, on regard to the surveillance interrogatories, in page 26 of our initial brief, we read the interrogatory itself, which was about both plaintiffs. It didn't differentiate between them. And this is on page 1179 in the transcript. The answer was basically yes, and it listed the dates, which were in May of 2009 and 2 dates in June of 2009, so it was well before the trial. And then shortly after that, a juror asked the court what the presentation of the interrogatories was related to, and the court's response was that the relevance would be explained during closing arguments. And so the relevance was explained to them that it was because the Shavers were spying on them.
Okay.
And that was the only relevance that had ever been announced at any point in time, whether it was raised before the trial, whether it was raised during the trial. That was the only relevance. In regard to the color of the light, the initial brief, actually both briefs together, you get a very good feel for how the testimony went. Mr. Carpenter, who said that, you know, he thought the light was green, so that's what he said. Mr. Shaver said that he had gone into the intersection and was waiting when the light was still green, but didn't know what color it was. And you know how that is. If you're under the light, you don't always see it. The other driver said in his deposition that the light was red, and then in court said, well, it was either red or I was not moving because the car in front of me wasn't moving. So yeah, he equivocated a little bit, but at one point he had unequivocally said, yes, the light was red. The jury heard all of that information. They heard about the delay, and then Trooper Mosesman came up and pretty much just, you know, resolved that question for the Carpenters right there and shot that down. In terms of the damages, I really, the problem is that We did, by the way, move for a directed verdict on the damages. I'm pretty sure the record will show that the insufficiency of the evidence in terms of supporting the future medical award for the low back damage medicals, the causation for the shoulder, and the future medicals for Mrs. Carpenter were addressed in the motion for directed verdict.
Questions not based on reasonable medical certainty. Nobody was objecting to the form of those questions.
Mr. Haas objected to almost the form of almost every question that was asked. A lot of the doctors were presented by Video Depot, and I don't recall from looking at the record whether they tried to address the objections, but lots and lots of objections made it into the record right off of the video, so I'm not sure how that approach was taken. But he did object to the form.
And frankly, before the oral argument, I had not realized that head damages had been waived. How was this explained to the jury? Was this done at the front of the trial? Or
What damages?
That Mr. Carpenter's head injuries had been waived since he wasn't wearing a helmet. How was that explained to the jury?
I don't recall at this point in time. And I do know that the defense, originally we were probably looking very heavily at that, but in terms of what happened in this trial, none of the physicians that were testified talked about that. And he did have some fairly significant facial and head injuries, but I don't think it came in through his testimony, through the doctors, maybe through some ER records that they might have looked at would be their only chance that they would have seen that. So, and I think that answered most of the court's questions.
Thank you.